Rachel, could you explain to me what actually is unfair dismissal?
When an employee is dismissed, he or she can potentially claim unfair dismissal. Generally speaking, the employee now needs to have 2 years of continuous service in order to claim unfair dismissal. There are exceptions to that, and it's when the dismissal is in a very special circumstance. For example, if a woman was dismissed because she was pregnant, she wouldn't need the 2 years.
And how does an employment tribunal decide if a dismissal was unfair?
Well, the starting point is always the reason for dismissal. There are 5 potentially fair reasons for dismissal, and that can relate to a person's performance, conduct, redundancy, breach of some kind of law, or a kind of 5th ground, which is a catch-all known as for some other substantial reason. If the employer fails to show the tribunal one of these potentially fair reasons, the dismissal will be unfair. If the employer shows the tribunal that they had one of these fair reasons for dismissal, the tribunal will then go on to decide whether or not the employer acted reasonably or unreasonably in dismissing that employee in those circumstances.
That seems to give a tribunal a very wide discretion, doesn't it?
Well, not really, in that the tribunal can only find that it was unfair if it was outside what is referred to as the band of reasonable responses. In other words, if no reasonable employer would have made a decision to dismiss in those circumstances, the dismissal will be unfair.
That seems to me to be rather a harsh test, isn't it?
Well, these kind of tests are very case law driven. The Employment Tribunal will have in front of them all the relevant case law that has set a precedent for how they must decide these cases. If I could use the example of conduct, if you're dismissed for misconduct, gross misconduct or misconduct only, the tribunal will apply a 3-stage test. First, they'll ask themselves whether the employer had a genuine belief that the employee had done that conduct. Secondly, they will want to be satisfied that there were reasonable grounds for that belief. And thirdly, they will want to be satisfied that they undertook a reasonable investigation into the issue. The tribunals very much focus on the procedure, and they'll want to see that the employee was given a fair hearing. For example, they will want to see that he or she was forewarned of the allegations, given an opportunity to attend a hearing and put forward his or her response, if you like. They will also want to see that the employee was given a right to appeal and advised that he or she could be accompanied to the disciplinary hearing. So they will look at the whole process as well as the outcome. In these circumstances, the ACAS Code of Practice on disciplinaries is also very important, and the tribunal will want to be satisfied the employer has followed the general bones of that.
So if I think I have been unfairly dismissed, what should I do?
Well, pick up the phone and call us. We're more than happy to have an initial free consultation over the telephone to see if it's something that we think you may be able to pursue in the Employment Tribunal. I would urge you to bear in mind the very strict deadline, though, for lodging your claim in the Employment Tribunal. The claim needs to be lodged within 3 months less 1 day of the date of termination. That's a very strict deadline, and the tribunals very, very rarely allow a claim to be lodged beyond that time frame.